The room is quiet, not the type of quiet that feels calm, but that type of quiet that feels as though something is about to break. You can cut the tension in the air with a knife. Across the table sits a senior judge, a man who has spent decades working in the South African judiciary system, a man who has written judgments, presided over courts, and climbed to one of the highest positions in the judiciary. And now, under oath, he is being asked a single question. Did you take the money? He does not hesitate. He says, I did not. This is not about a judge. This is about a system that we have become familiar with on this channel because of the Madlanga Commission. Now, my name is Carri, and thank you for watching. It would do me a great honor if you could hit that like and subscribe button. It just lets the algorithm know that we are here. Judge Aubrey Ledwaba has been recommended for appointment as the Judge President of the Gauteng High Court. But comment below what you think. Do you think that this was appropriate, non-appropriate? Do you think that he should have been given a chance to tell his side of the story? I'm always interested to know your thoughts. At the center of the story is a judge who we have spoken about a little bit on this channel, Aubrey Ledwaba, and he is the Deputy Judge President of the Gauteng Division of the High Court, one of the busiest and one of the most powerful judicial divisions in South Africa. And by the time of this interview, Ledwaba is not just another judge, he is the acting head of the division. And more importantly, he is the only candidate being considered for the position of Judge President, which is the permanent leader of this position. The vacancy exists because the previous Judge President, Dunstan Mlabu, has been elevated to Deputy Chief Justice, which means this interview conducted by the Judicial Service Commission is not routine, it is decisive. And spoiler alert, Ledwaba would be successful. He would be recommended to take control of a division responsible for a significant portion of South Africa's most serious legal matters. Now, before any discussion of leadership, vision, or reform, there is something else, something that cannot be ignored, something that came out at the Madlanga Commission. Now, these allegations, they did not begin in court. They began inside another process entirely, the Madlanga Commission, a commission tasked with investigating something far bigger than any one case: criminality, political interference, and corruption in that very system charged with keeping us citizens safe, the criminal justice system itself. The kind of corruption that, if proven, doesn't just affect individual cases, it affects everything. During that testimony before the commission, a claim is made, a claim that would eventually reach the highest levels of the judiciary. On the 21st of October 2025, an investigator identified as Witness A takes the stand. And what they say is explosive. According to testimony, an informer had come forward with a claim involving alleged member of the Big Five cartel, Katiso Molefe, that 2.5 million rand had been set aside. Not for a business deal, not for a political transaction, but to secure the release of a man accused of murder. That man is Katiso Molefe, described in reports as the alleged criminal belonging to the Big Five. Months earlier, Molefe had been arrested with regards to the murder of Armand Swart. We have covered that case extensively on this channel. This case, by all accounts, was very serious. By March, the Vereeniging Regional Court had denied Molefe bail. The reasoning was clear. The concern is that he might flee. The concern was not hypothetical because Molefe had previously been caught with a fraudulent Lesotho passport, which meant the court believed that he had both the means and the willingness to escape. At this point, the process should have been straightforward. remain in custody, await trial, but that is not what happened because the decision didn't end there. It was appealed. The appeal was heard in the Gauteng High Court in Pretoria by none other than Judge Aubrey Ledwaba. Now, Ledwaba overturned the lower court's decision. He granted bail and set it at 100,000 rand. And with that ruling, everything changed because months later, when witness A speaks to the commission, the decision becomes the center of something far bigger. According to the testimony, the 2.5 million rand payment was allegedly intended to secure Molefe's release. But here is where things start to blur. Witness A cannot say who the money was meant for, not definitively, not clearly, and states that the money may have been intended for a judge, a prosecutor, or possibly others, but it does not name Ledwaba directly as the recipient. Witness A does not provide evidence. He does not confirm that any payment was made. In fact, he admits something critical, that he doesn't have evidence, and witness B would support the claim. Yet, despite the uncertainty, despite the lack of indirect evidence, a name drop at the Madlanga Commission is something that is explosive. And the question becomes no longer just about Katiso Molefe. It is about the possibility, however unproven, that a judicial decision may have been influenced. By the time this information reaches the public, the reaction is immediate. There are news headlines, and they reach the Judicial Service Commission, and they become the first issue that is raised when Ledwaba sits down for his interview.
We could not dismiss the objection from the Helen Suzman Foundation and the objection from Mr. Pitso Ramatsebe. Now, to start with the one from the Helen Suzman Foundation, we've decided that you must answer it openly in this forum. Firstly, it relates to the fact that you were mentioned in the Madlanga Commission adversely. You remember what happened there?
Yes, I do remember what happened there.
Yes, maybe you should take us through from your perspective.
From my perspective, I can just mention that I heard for the first time in the media that there is a witness that alleges that there was money that was put aside in the amount of 2.5m. That witness indicated that he was not sure whether the money was to be given to me or to the prosecutor. I also just want to mention that after that witness gave evidence at the Madlanga Commission, I was informed by the Chief Registrar that the Commission had requested a copy of the proceedings and a copy of my judgment. I can just mention in passing that before those documents were given to the Commission, I was not given an opportunity, or the Chief Registrar did not contact me to look as to whether there are any corrections that I needed to make on the proceedings. But I take that as being to my benefit, because if that was done, other people could have thought that maybe I could have changed some of the things that happened on record. Immediately after listening to the evidence of witness A, I instructed an attorney to write to the Commission and to check with the Commission as to why didn't they give me an opportunity or warn me that there will be evidence that would be given against me. And in the response, the Commission stated that they will be preparing a report to the President in December, and they'll deal with that matter. I also need to mention that I did inform the Commission that if nominated, I intend applying for the position of the Judge President of the Gauteng Division. And the response of the Commission was that they'll ensure that I'm not prejudiced in any manner, and they will ensure that my matter is dealt with before the JSC sitting. That has not been done. The Commission has not yet come back to me. What I can say about the allegations that were made against me is that the witness A indicated that witness B will corroborate or would give more information about this evidence that I could be involved in arranging that bail should be granted for Mr. Molefe. The Commission further indicated to me that the reason why they did not inform me about the evidence of the witness is that they only had that evidence for the first time when the witness was testifying. And when I was busy with my preparations, I asked myself that if that evidence was only given for the first time at the Commission, how did it come that one of the commissioners should tell the witness to mention the name of the judge that was involved in that? That aspect is neither here nor there. I can also mention that I dealt with the bail application of one Mr. Molefe. It was opposed by the state. And when the proceedings started, the state advocate did not ask for my recusal. I'm mentioning this aspect that he did not ask for my recusal because the witness stated that they informed their seniors and their prosecutor about what they heard from their informers. The proceedings went on. I granted the appellant or applicant bail. And what is most interesting that I need to state to this Commission is that about a month or 2 months after Mr. Molefe was granted bail, he was arrested, and 4 additional charges of murder were added to his charges. The magistrate refused bail, and the matter went to there was an appeal to the High Court. I need to mention that I did not take any part in appointing a judge who was to hear that matter. The matter was heard in the Johannesburg local division, and I think the retired DJP allocated a judge to hear the matter. And in that appeal, the court again granted Mr. Molefe bail in the amount of 400,000. In the media, what was mainly published was that I granted bail to Mr. Molefe, but when the other court granted him bail, they did not make news in the media. Again, the witness A also mentioned in the social media that he instructed the prosecutor to appeal against my decision. The prosecutor told him that there were no prospects of success. And that is where the matter is. What I can say is that when I dealt with that bail application, I dealt with it in the normal course of my duties. I also want to mention that it was not the first bail application that I dealt with as a DJP. And this incident happened during recess. Usually, if there are bail appeals or urgent matters to be attended to, I would go to my office and check, and if there are no judges, I'll deal with the matters. And when this bail of Mr. Molefe was entertained. It was not the only matter that was on the roll. There was another bail application that I also entertained. Yeah, I think I can go up to that.
Yes, there are some further questions that arise from these objections, if you don't mind. The first one is whether you have answered directly that you took the money or did not take the money. I think we need to get that out of the way. The implication of the allegation is that Mr. Katiso Molefe made 2.5 million rands available for a payment of a range of people, which could include the police, the prosecutors, and even the judge. And the big elephant is whether or not the judge took bribe money. Can you just answer that?
I did not take any money in respect of this bail application. I did not know Mr. Molefe at all. I've never met him. I dealt with this matter in the ordinary course of my duties. And why I dealt with that matter, all bail appeals are regarded as urgent. Hence, I'm saying there were 2 bail applications that needed attention during recess, and there was no judge who was available that I could allocate these matters to. And it was not the first time that I would deal with the bail application of applicants. Mention was also made about me being involved in the bail application of Mr. Ntanzi, one of the accused in the Senzo Meyiwa case. Because there was no judge available and I realized that it is an urgent matter, I adjudicated on that matter and gave a ruling that Mr. Ntanzi did not be granted bail.
Yes, the second thing that arises is why, as the DJP, you did a bail, because ordinarily those things are done by, I would say, puny judges.
Commissioner, as a DJP, my job is not only just to allocate matters to judges. And I also do other work. I also do trials. I also sit in special motions. I also do bail application, so that I should be aware of what is happening in my court, so that when my judges complain that they are overloaded with work, I should have tasted, I should have done that work. Because usually we would sit with the judges and just for example, they'd complain that they are receiving about 40 unopposed applications, that number should be reduced. And if, as a DJP, you've been in those courts, you've seen those documents, you appreciate what your judges are saying. And even in my stint as a DJP, there's a time where I also did urgent court, just to have a good feeling of what is happening in the court that I'm a leader as a DJP.
The third question that arises out of this is that your judgment was a poor judgment. It did not engage with the correct principles because the nature of the offense placed the onus on the accused, and the reasons that you gave were poorly motivated. And this is being said in the context that this was an entire scheme arranged by Mr. Molefe to pay his way out of prison.
Commissioner, I deny that the judgment was a poor judgment. I gave reasons why I thought that there were exceptional circumstances justifying that bail should be granted. In some of the issues that I raised with the prosecutor considered that there were material misdirections on the part of the magistrate. I can think of one part in the judgment of the magistrate where the magistrate said, I'm not going to grant you bail because you cannot afford the amount of bail. And I also mentioned in my judgment that that was a misdirection because if an applicant wants bail, the relatives, other people can pay bail for him. The other misdirection that I mentioned in the judgment was that the magistrate said much as the applicant testified or made an affidavit that he had a house worth about 17 million, the applicant was supposed to have produced a title deed. And that evidence of the applicant that he's got property worth about 17 or 14 million was not disputed. The other aspect that was raised by the magistrate that is in my judgment was that the applicant was supposed to have produced his salary advice showing how much money was he making a month. And that is an allegation that was not disputed by the state when this bail application was entertained. So I fail to understand on what basis is it alleged that my judgment was a poor judgment. And as I've mentioned earlier, that witness in particular told the prosecutor that they should appeal against the decision. There was no appeal. And I can also mention that when my other colleague gave bail to the same gentleman, as far as I know, there was no appeal lodged against the judgment of my other colleague.
The last question on this topic is from HSF, who say that your candidature should await the outcome of the Madlanga Commission. Any response?
Commissioner, my response to that is that this application is not about me. I'm looking at what is in the best interest of the Gauteng Division. I think the division needs a leader. If the appointments are going to be stayed because there are other recommendations that needs to be made, I see this as not being in the best interest of the judiciary. I can also just mention that there have been many allegations made against judges, which have not yet been finalized, but some of those judges did apply and then they were appointed. Just to mention something again, it was in the media that there's a case, criminal case against myself, the DCJ and Judge Ratamokwatle, CAS 130/2/2026, wherein one Mr. Tefo made an affidavit and alleged that the three of us have received an amount of 35 million. Now, if we are going to wait for this matter to be investigated before other important positions can be filled, I don't think it's in the best interest of the judiciary. I can also mention that there was summons issued against me for an amount of 50 million by one attorney, Mr. Tobani, alleging that by refusing to grant bail to Mr. Ntanzi, his client instructed him to withdraw as attorney of record, and now he thinks that he's lost some income because of my decision. To sum it up, if there is an allegation against the judge, the Chief Justice and even the former Chief Justice has made it clear that if there is anything that needs to be made against the judge, it should be reported to the JSC. And these matters that I've mentioned have not been reported to the JSC. I can also just mention again that if one is faced with allegations of this nature which affect the judiciary, some of the decisions are not decisions that are easy to make. And whatever decision I make to apply and the decision to continue with my work and not taking special leave were based on, I consulted, I discussed the matter, some senior retired judges. If their names are requested, I'm willing to do that. But they also told me that before you take a decision to take special leave or before you decide whether you should step aside, in quotes, one should look at the seriousness of the said allegations against you. And in that discussion, they were also of the view that with what has been presented, the hearsay evidence of witness A, and what is published, the judiciary would be crippled if always there are allegations and that a judge should step aside.
Yes, so you're saying the allegations are serious, but there's no evidence to support them.
You know, the way they've been presented, I hesitate to say that they are serious because that is just pure hearsay. And if these allegations were serious, if we look at the evidence of witness A, he stated that he informed his superiors about this plan. And I think that there were other steps that they could have taken to ensure whether these allegations carry any weight or not.
Then comes another layer, the quality of the judgment itself. Critics, including testimony at the commission, have suggested that the ruling was perhaps poorly reasoned, that it relied on exceptional circumstances without clearly defining what those circumstances were. And Ledwaba rejects this completely. I fail to understand on what basis is it alleged that my judgment was poor. And he points out something important, that despite all the criticism that he has received, no appeal was ever filed against his decision. Yet outside the room, the story continues to evolve because according to testimony, witness B describes as feeling deeply uncomfortable during the bail proceedings, as she believed that the outcome had already been decided before the arguments were even complete, and she even asked her superiors for permission to leave the courtroom before anything happened, before anything was decided. And according to her account, the judge respected a standard condition, the requirement that the accused report to a police station, a condition that is often used to monitor compliance. He reportedly described it as an unnecessary burden. We know that Katiso Molefe is arrested again, charged in connection with additional murders. And once again, the question of bail arises. This time, the decision is made by another judge, Brad Oneness. And once again, bail is granted, this time set at 400,000 rand. Ledwaba points this as evidence of inconsistency in how the situation is being portrayed. He notes that while his decision made headlines, the second bail ruling did not receive the same attention. Ledwaba has also been facing headlines with regard to Paul O'Sullivan. It is alleged that he is the one who granted Paul O'Sullivan that crazy court order that says that you have to give him 48 hours notice before you arrest him. Well, it turns out that according to a statement that was released by the judiciary, he was not the judge who did this. It was another judge instead. And then there is something else that is raised here, because no formal complaint has been lodged against Judge Ledwaba, not with the Judicial Conduct Committee, the only body with the authority to investigate judicial misconduct, which means at this moment, there is no official case against him, only testimony raised at the Madlanga Commission. According to reports, options were discussed with Ledwaba that the situation was serious enough that perhaps there was talk of special leave. And apparently, Ledwaba allegedly refuses. He declines to take special leave. He says he intends to seek legal advice. And more importantly, he wants the opportunity to present his side of the story. At the same time, he raises another concern that after hearing his name being brought up in the Madlanga Commission, and he instructed an attorney to contact the commission and ask them, why has he not been informed? Why has he not given the opportunity to respond when his name entered the public space? According to him, the commission initially assured him that the matter would be handled and that it would not prejudice his application. But by the time the JSC interview, which happened today, he says something else. He said, the commission has not come back to me. Now, Judge Aubrey Ledwaba has been recommended for an appointment as Judge President of the Gauteng High Court. And this is after he sat in the chair and he answered questions, and his answers were suitable to those who were to decide. But comment below what you think. Do you think that perhaps there is something more going on here? Do you think that he should have been afforded an opportunity by the Madlanga Commission to clear his name before this happened? Comment below what you think. I'm always interested to know your views. Now, thank you for watching. Thank you to all my members. You sponsored the plant fund behind me. Look how beautiful they're looking. And thank you to all my subscribers and my viewers. You make this possible. And remember, it is dangerous out there. So remember to watch your back.